Welcome to the Practice Podcast, a show created by lawyers to help lawyers in life and business without all the complicated lawyer language. Let's welcome Bast Amron founders and your hosts, Jeff Bast and Brett Amron.
Hey, Jeff.
Brett.
How are you?
I am well.
Are you, though? We're okay. We're okay.
I have my health and my family and my esteemed partner, and we have a friend here in the podcast room. Life is good. All things considered.
I'm with you.
We are recording this after Election Day, and we're not going to talk about that at all.
No, we're not.
Because this is not a political podcast.
No, it is not.
No, it's not. Are there other things that are off limits for you, generally? Like,
do you mean in conversation?
Conversation, like with family? Do you have like no religion, no politics, no, I don't know. Is there anything for Brett Amron?
For me personally, or my family in general?
For you with people.
And my extended family? No, there's really nothing off limits. But if somebody asks me a question, I don't want to answer it, I'll just say, you know what, I'm not going to answer it.
All right, so tell me what I should ask you that you won't answer.
I'm not going to answer that.
Nice. Well done. Our guest today is Brett Marks.
No relation.
No relation. It's going to be two Bretts. It might be a little confusing, but I think we'll be okay. He's got a very distinct, he's got a good radio voice, I think.
Agreed.
Podcast voice. Brett Marks is an attorney at Akerman LLP. He specializes in bankruptcy and restructuring law. He represents troubled companies, creditors, asset purchasers, trustees, and committees in Chapter 7 and Chapter 11 cases, out-of-court workouts, and litigation. He also advises officers and directors of insolvent companies, and he defends them against breach of fiduciary duty claims and other allegations of malfeasance, sometimes by this firm, our firm, Bast Amron, I mean. When I said this.
It wasn't clear, but thank you for...
His expertise spans various sectors, including professional sports, gaming, telecommunications, real estate, finance, technology, and his work has been recognized by several publications, including Chambers USA, The Best Lawyers in America. He is one of the best lawyers in America. And Florida Trends Legal Elite. And he's also the proud father of two lovely children.
He is.
Which are two young adults, I should say. Welcome, Brett.
Welcome. Hey, thank you very much for having me. This looks like it's going to be fun.
We're excited. Yeah, Brett Marks came in.
That's all right.
Yeah, Brett came in with a little unease. He was like, "What is this thing? I didn't do any prep." And we had
Don't worry. Kid gloves, we'll take care of you. We'll have a nice conversation.
Well, I will say off the top that's the real Brett Amron, because my actual first name is David.
That's true.
Oh, yeah.
So and my middle name is Brett.
Right.
But I've always been called Brett since literally the day I was born.
Yeah, tell us how that happened or why.
This is it's my father was a lawyer, so there's some negotiating that goes into it. So when I was born, I'm Jewish, and my mother wanted a good Jewish name like David. My father was in law school at the time. He was in his third year of law school at Mercer, and his favorite TV show, this was the late 60s, was a TV show called Maverick with James Garner as the star, and the title character's name was Brett Maverick.
Nice.
And that was my father's favorite TV show in the world, and he wanted me to be named Brett after Brett Maverick. They had a dispute over the name. So my father, the negotiator that he is, so to speak, they negotiated a deal where my legal name would be David, but they would always call me by my middle name, Brett. And since I never had a choice in the matter, it wasn't a conscious decision on my end to go by my middle name.
Is there a written document somewhere that lays this agreement out? I mean, that's amazing.
But that would be funny if it existed. And then I have a younger brother who's 2 years younger than me. And his name is Jason Marks. He's a local attorney also. And when Jason was born, my father attempted again, because Brett Maverick had a brother.
Wow, you really like the show.
Yeah, had a brother on the TV show named Bart Maverick.
Oh, no.
And my dad tried for Bart.
And Bart.
But my mom drew a line in the sand and said that wasn't going to happen.
Yeah.
So he's a Jason.
Is his middle name Bart?
His middle name is not Bart, it's Ross.
Okay.
So, and I don't even know where that comes
from. So here I thought you changed to call yourself Brett after you met me. I thought you wanted, that's not.
Well, okay. I will tell you, I grew up in Tampa, and I initially started practicing law in Tampa before I came down here. And there were no Bretts. It was somewhat of a unique name, certainly in my high school.
Yeah.
And in college, I didn't know any Bretts. And when I first started practicing, I spent 5 or 6 years in Tampa before I moved down here. And then I moved to South Florida in like 2002. And all of a sudden, I started. One of the first people I met was Brett Amron.
Mm-hmm.
And
is that right? I want to come.
And he
back
stayed.
I'm going to come back to that.
And
story.
he stayed.
What brought you down here from Tampa to South Florida?
Well, I will tell you, I had my wife and I were both had jobs. We both needed to work, and we just had our first kid, Danielle. She's 22 now, and because we still had to work, we had to put Danielle into daycare at a very early age, 3 months.
Is your wife a lawyer as well?
No, she's a geriatric care social worker.
Nice.
Yes.
My wife is also a social worker.
Well, at the time, though, she was a drug rep for a pharmaceutical company.
Okay.
And they only gave her a certain amount of time. It was a full-time job as opposed to what she does now, which is part-time. And at the time, it was a full-time job, and they only gave her 3 months of maternity leave, which is somewhat common. So we had to put our daughter into daycare pretty much full-time, and I hated it. And at the same time, I was getting calls from legal recruiters in South Florida asking me to consider moving down because I could get paid a lot more money in South Florida than what I was making in Tampa.
Just because of the market, you mean?
Yes.
The legal market.
The bigger city, the market, right.
And higher hourly rates. And at the same time, the law firm I was with at the time, which is the same firm I'm with now, Akerman, they also moved me. They also asked me to move down.
Oh, okay.
So I started weighing it, and the difference in compensation was pretty much what my wife was making at the time. Right. So we decided that if we moved down here, she wouldn't have to work. She could, raise our child.
Yeah.
And that's why we moved down here.
Nice.
What area of practice were you focused on when you started, and did that change when you moved down here to Miami from Tampa?
I started right off the bat doing bankruptcy work. I worked for a small solo practitioner. It wasn't a conscious decision of mine to do bankruptcy. It was literally the first job offer that I got. I came out of what I'll call a bottom-tiered law school, and it was not as easy to get a job at that point in time. So it took me a while. Listen, if somebody had hired me at a personal injury law firm, I probably would be a personal injury lawyer, or workers' comp. But the first guy to hire me, who's turned out to be one of my best friends and mentors, taught me bankruptcy law, and I started from there and have never looked back. And, as you both know, it's a niche practice. Not a lot of people do it.
Or do it well. Less people do it well, and you do it very well.
Tell us about it. What do you?
The best part about bankruptcy law and being a bankruptcy lawyer in relation to all of our friends and colleagues that have other practices areas, they're all scared of bankruptcy because bankruptcy has its own rules, its own bankruptcy code, kind of like the tax code. It has its own courts.
Right.
And everybody thinks for whatever reason that you need to be a rocket scientist.
You do.
To be a bankruptcy lawyer.
Don't reveal. This is public. Don't reveal.
Lots of people listen to this.
I am proof positive from a guy who came from a bottom tier law school.
Is that NYU, by the way? Was that bottom tier law? Oh, that's good. That's good.
That's
right?
good.
Thanks.
I have his bio here, so I know where it is. I'm not going to.
So, and as you both know, learning bankruptcy law and being part of the community and then reaching out to your friends, it's a great way to develop your own line of business because all of your friends, colleagues are anxious or scared about bankruptcy. I don't want anything to do with it. Brett, you handle it. Brett Marks.
It's a specialized area, and it is a niche area, and it's code-based practice. And you do have to have some familiar. It's a foreign language in some respects. You go into this court, and the judges do nothing but bankruptcy. They know they know the law. It's not like, state court, you can sometimes get away with some stuff. The judge may or may not know the law in this particular issue as well as you do. But in bankruptcy court, there's no latitude for that.
Well, I have a case in particular right now where it's basically a case that should be in bankruptcy. It's a fraudulent post-judgment fraudulent transfer case.
Okay.
And it's in front of a state court judge. And the state court judge respectfully just doesn't understand the types of defenses associated with these fraudulent transfer cases. But that's because, on Mondays, he's doing a slip and fall case.
Right. No, it's not their fault.
Tuesdays, he's doing a trespass case.
Right.
Wednesdays, he's doing a medical malpractice case or a zoning case.
And thousands of cases on their docket.
Yes.
Right?
Yes. And so I've had a lot of trouble with this particular case establishing concrete defenses for my client. And I know full well that if I was in a bankruptcy court in front of a bankruptcy judge who sees fraudulent transfer cases every day, I would have a much better chance of establishing defenses for my client than I do in state court.
Well, I bet the plaintiff knows that too.
Well,
that could be why you're in state court.
but in bankruptcy as well, it's not just listen, like you said, it's not rocket science. I tend to agree in the sense that like it's there for you to read it, to apply it, but there is nuance. A, that's why we all have careers and jobs. But B, it's the years of experience in bankruptcy and insolvency that gives that value. That people can't just, we always say, right? If you don't practice in bankruptcy court and you have a one-off case and you jump in, that's not a great idea. And you mentioned tax. There's not a chance I'm showing up in tax court. There's not a chance I'm going and handling a patent infringement litigation. I'm just not doing that.
Yeah.
Right? I'm going to go find somebody that does that has done that has experience and is really good at it. And the same goes for bankruptcy. The difference with bankruptcy, I think, is that we handle so many different things in bankruptcy. The code says this is how you deal with a liquidation or a restructuring or even a litigation. But then you pile on the substance, meaning, right, each different industries, different issues. And, you may have a slip and fall that you have to deal with in a bankruptcy, but you also may have a breach of contract, a D&O case, a fraudulent transfer case. There's so many different things that we have to be good at and know, not just the code.
Yeah, and it's an interesting area of law because you do get to experience all types of different ways to practice law as a bankruptcy lawyer. Sometimes, for example, we're transactional lawyers.
Right.
We're representing a purchaser who's going to buy assets out of a bankruptcy case. So we're working on or with asset purchase agreements and schedules and closing statements. Conversely, if we're on the company side, we're doing the same stuff on that side. There are tax implications in bankruptcy.
Yep.
There's litigation in bankruptcy. I mean, true trial work. And I think actually bankruptcy for young people, and I was taught this pretty early on, bankruptcy is a great way for young lawyers to cut their teeth in terms of learning how to practice law, because we're in court so much for our clients, at least, I don't go to court as much as I used to. I give that to the younger guys to do. But, a lot of what we do is in a courtroom, and we have mini trials. And then in some instances, we have full on 7-day to 2-week to 3-week bench trials. And even every once in a while, and it doesn't happen once, I think it's happened once in my career, you have a jury trial. I mean, you could have a jury trial in a bankruptcy case. Again, it doesn't happen that often. But so if you want to do trial work, if you want to be a litigator, I mean, there's tons of depositions, whether it's in the context of what they call an adversary action, which is a true litigation, or it's part of the main bankruptcy case where they call it a Rule 2004 examination. You're examining witnesses, you're looking at documents. So you see the transactional side of bankruptcy, you see the litigation side of bankruptcy, and then there's also the business side of bankruptcy, advising your clients on the economics of doing a type of deal. And that the economics could include a transaction. It could also include litigation. This is what it's going to cost. This is what you could potentially recover. These are the downsides. So there's a lot of nuance with what we do. And I think practicing bankruptcy law in particular makes you a pretty well-rounded lawyer.
Wow, you sold me. Sign me up, man.
Yeah, I'll do it.
Where do I sign? I'm sitting here wondering, would Brett, because you said, had you gotten a job with a personal injury lawyer, at a law school, you'd be sitting here talking about personal injury. Would you be so animated and enthusiastic about it if it was personal injury? Maybe you would be. Maybe that's you.
I don't know the answer to that because this is all that I know.
Right.
I mean, sometimes we have to branch out. I had a friend recently. In fact, I handled it yesterday. A childhood friend, high school friend, who has young daughters that are in middle school, and got into a dispute with another parent. And my client, my friend, submitted, pursuant to the school guidelines, a bullying report to the school outlining how her daughter was being bullied by some other kid. And then the next thing you know, the child was subsequently expelled from the school.
Oh.
But there was a big buildup.
It wasn't
a one,
it wasn't a one-off. Right.
But at the end of the day, the parents of the affected child sued the school, and then also sued my friend for libel and slander.
Wow.
Oh, boy.
So I had to deal with that.
Nice.
So you learn
sure. We all get those calls where you're outside
I did a mediation yesterday to get my friend out of this, and it's not bankruptcy,
right?
But you also understand this. I've done, like you guys,
it's litigation
mediations,
and
there's litigation involved, and so you can, having that background and that experience makes you effective, even if you're not necessarily handling a bankruptcy centric type case or dispute.
Yeah. I mean, I've always said that I think bankruptcy lawyers are the best litigators because we do so much litigation. We have such a sense of I'm looking at Brett Amron's face and he's thinking of all the examples where that's not true. And I'm sure there's lots of them. But because of the experience and because of the sort of holistic view that I think bankruptcy lawyers take, we are much more, in my opinion, results oriented, focused on an outcome.
Sure.
And sometimes that involves a court, sometimes it doesn't involve a court, but ultimately bankruptcy is a system of consensus. I mean, it works with all of us. The idea is that we're all better off by this company, in the case of a business, which is most of what we do, surviving in some form or fashion, even if everyone has to take a haircut. Everyone takes a little less than they're owed. And so there's a pain point for everyone. But what we work on is win-wins. A lot of our outcomes are win-wins. Just because I win doesn't mean you lose. We're both giving up something. And so, I don't know.
I think the difficult conversation to have with people that are part of this community, part of this process, is explaining the economics of bankruptcy, because you are, in fact, for not always, but 95% of the time dealing with an insolvent company. Mm-hmm. And there's a lot of people that want to chop up that company to get their piece of the pie. And you're really not talking you're really not talking about dollars, you're talking about bankruptcy dollars.
Yeah.
And I try and explain to my client, the bankruptcy clients, when I'm representing a creditor, mm-hmm. that bankruptcy dollars are different than real dollars. And there may be a situation where a company that's in bankruptcy is offering to pay its creditors back 15 cents on the dollar. And on the surface, that sounds horrible. You're taking an 85% haircut. But at the same time, you also have to counsel your client that 15 cents on the dollar may not be that bad,
right,
given the economic situation of this debtor and the fact that its assets may be subject to a significant lien,
right?
Or you're not the only guy that has his hand out, waiting for money. There's 100 other people like you, and everybody's getting what they can out of it. This is not about who's
more right or who's more wrong. It's about sort of equity. It's actually one of the last bastions of equity in our society. I mean, where else do we have something where we take the thing and we kind of divide it up fairly? Yep. That's like the concept. We don't really have that a lot until other than like preschool.
And then the flip side that you have to counsel them is, all right, you're not happy with 15 cents on the dollar. I get it. But this is what it's going to cost you
to fight.
For me to go into court and fight and try and get you a little bit more.
But you might get a bigger piece of a smaller pie at that point. So it may or may not work out in your
And how much did it cost you to get there?
Exactly. And the cost.
Which is the factor to consider. Right.
Which is what the point I was trying to make about litigation is that litigation often has that same, ramification. We can go fight and fight. It's going to cost you. And can the other side, and if you win, that's not the end of the day. Getting the judgment is not the end of the day. You then have to collect on the judgment, as Brett, you were talking about before. You're facing one of those fraudulent transfer claims on a collection case. But we understand the economics, and we're thinking about that too. It's like when I sue, we've had clients come to us and say, we want to sue this, supplier. Oh, really? What percentage of your, inventory do they supply? Oh, they're like our largest supplier. Okay. You understand that when we sue them, they're not going to continue supplying. Oh, really? Okay. Well, yeah, that's what happens. Typically when you sue someone, that's the end of the relationship. So a lot of people just aren't thinking that way. I think we look at litigation from a more generally a business-minded approach.
Well, I think you have to, especially as it relates to bankruptcy, because for the most part, bankruptcy litigation, there's no what are called prevailing party attorney's fees provisions.
Yeah.
So unlike, Florida statutes or some federal statutes that are out there, and even if you have a contract, the contract may have prevailing party attorney's fees, but those aren't typically awardable in bankruptcy. So most of what we do, the client's not going to get compensated or recover the attorney's fees that they expended. One of the things that all of us have done, significantly throughout our careers, and we touched on it 15 minutes ago or 10 minutes ago, is preferential transfers and fraudulent transfer cases. I get clients that are sued for a preferential transfer. For your audience, that's that transfer that goes out of an insolvent company within 90 days before they file the bankruptcy petition, and they could get sued for $100,000. And I have to tell the client, well, listen, it's going to cost you $25,000 or $30,000 to defend this case. And by the way, you're not going to get any of that money back. That even if you win, you're not going to recover your attorney's fees. So you have to take that into consideration when you're deciding how to defend the case and or settle the case. And, typically, and we've talked about this offline before, in the context of director and officer liability claims, it's what is it going to cost to defend the case and what's the risk factor? And then you equate that and then you come up with a number. And a client's like, well, why should I have to give any of this money back?
Well, and add to that conversation when the client is still owed money.
Yeah. That makes it even worse.
They want to pull their hair out.
They do.
Wait. I owe money. I got paid a portion of what I'm owed, and now I got to pay that back.
I bent over, and before that, I bent over backwards to try to accommodate and help support this company, this client and customer of ours, and gave them a payment plan and extended credit and did all these things, right?
I have a pat response to that, which I learned very early in my career, which is don't blame me.
Yeah.
Don't even blame the lawyers on the other side. Blame Congress.
Right.
Because it's the way that they pursue these claims is based upon a federal statute enacted by Congress. If you don't like the statute, go to your congressman and complain.
Never happened.
Yeah, of course, because they forget about it afterwards.
I mean, I know
the theory of him is makes sense. The theory being that certain creditors were preferred over others, and so let's rewind the tape, to where the company had more assets, bring all the money back, and then we'll distribute it fairly. But we all know, the three of us sitting here, and maybe the four people listening, just kidding, 4 million. Know that it doesn't work that way in practice. So,
Well, listen, in practice, the money comes back in, and in many instances, it's used to pay the lawyer fees associated with dealing with the bankruptcy, and it's not technically going to the creditors; it's going to the professionals. That's another thing that's based upon a federal statute.
Yeah, and I'm
happy for that federal statute because that's how we get paid, and that's how we earn a living.
And as a feature of many of those settlements, the creditor who's owed money, still owed money, and is now being asked to give back what they got, is also asked to waive their claim as part of most resolutions.
Which they wouldn't end up getting much, if anything, back.
They wouldn't, but in theory, the whole idea, it does undermine the entire purpose of this, this concept. Anyway, so we're not going to change that.
You've been at one firm now for a long time. The longevity.
What is it, 85?
Chronologically, I came out of law school in 96.
Okay.
I started working for a small one-person law firm. It was called Dennis Levine and Associates, and I was the associate. There weren't associates, plural. It was me.
Right. Yeah.
And the two of us, and we had a great practice, but, the economics.
Yeah.
And I think one of the interesting things about bankruptcy, and again, we touched on it earlier, is that it is a niche practice. And once you learn it, you really become, from a young lawyer perspective, a valuable commodity. Yep. So even though, again, I went to a bottom tier law school, because of the fact that I had 5 or 6 years of bankruptcy experience, I could almost write my own ticket as a young associate. There was a big demand, for people that knew their way around a bankruptcy courtroom and bankruptcy law. So I navigated to a bigger firm, Akerman, which is the firm I'm at now, where I got a really hefty pay raise to switch from the 2-lawyer shop to, at that time, I think we were 350 lawyers.
And what year was that?
That would have been 2001.
And so what advice would you give to a young lawyer who's making that? Not a lot of people make that move from small firm to big firm. And what advice would you
I think some of it's, happiness and choice of lifestyles. Again, I was a younger guy, but I was also in the process of having a family.
Right.
And having a family, as we all know, is expensive.
Of course, but going to work in big law, has this, the idea is that you're going to just become, you're going to work days and nights and weekends and everything else. And so was there a big adjustment for you going from a small firm to a big firm like that? Or
No. And I think part of that was the culture of Akerman.
Right.
It didn't feel like I was in a big firm because I wasn't asked to work crazy hours. Like you hear these stories, especially of our friends who grew up practicing up in New York, Boston, and Chicago, where they're there until midnight each night. Akerman was never like that. They've always had a pretty good, when developing young lawyers, that you don't need to work crazy hours to make good money. If you want to make great money, you can still work a ton of hours, and we'll bonus you and we'll increase your compensation. But if you don't want, and you want to work 1,600, 1,800 hours a year, you can still make a pretty good living working inside here.
It depends also on the practice area, because it could be a small firm within a big firm, and you don't feel the bigness of the firm because of who you're working with, and the office you're in, the type of work you're doing. So that also lends itself to maybe feeling a little bit, smaller.
Yeah, but as a young guy and trying to establish a practice, I did feel like the transition was beneficial for me, not just because of the increased compensation, but also because of some of the tools that I had that I didn't have at a solo shop for marketing, for example. Marketing people. I didn't have other people that I could help me on cases.
Expertise. So other areas.
I could bring in other types of work other than just bankruptcy. So
from a business development standpoint.
From a business development standpoint, for me personally, at that point in my career, as I was trying to establish, as we call it, a book of business, I found that I had a better chance of doing that at a bigger firm than I did at a smaller firm.
What's the secret of staying there so long? Because I know, to me, it's like an era that just is over with the younger generation. There's a lot more movement, and it's more acceptable, I think, today than it used to be, right? I know for us, we used to get resumes, and we'd see people moving from firm to firm over a year or two, and it would be disqualifying. Like, they're not,
I still feel that way, by the way.
But I think it has changed a little just by the nature of, sort of the market and generations. I just feel like they move around more.
But it's more, I think it's less common to see lawyers who have practiced at the same firm for 30 plus years or whatever it is, 20 plus years,
What do you think has been sort of the secret to staying?
I did have there was a break. So when I left, when I was at Akerman in Tampa, and I told you before I was considering moving to South Florida, my younger brother was part of a firm down here called Kluger Peretz Kaplan in Berlin. And it was a 40 lawyer firm, I think, at the time, and they matched the offers I was getting from the big firms. And it gave me an opportunity to work with my brother, who I'm very close with. And so I did have probably 7 years I don't remember much of it, to be honest, but 6 or 7 years at the Kluger Peretz law firm, which was a medium-sized shop. I didn't feel much of a difference.
Right.
Being at Kluger as opposed to Akerman, because
Akerman Tampa.
It's Akerman Tampa, and even Akerman, South Florida, because the office sizes were relatively the same. When I was practicing in Tampa, we had 35 lawyers in the office.
So even though you're at a bigger firm, the office itself was
it didn't feel different. The only difference was that we would have monthly meetings where like everybody was there.
Right.
And while at Akerman you don't have that because there's 700 plus lawyers. Occasionally we have video conferences where 700 people are listening into what firm management had to say. I felt like I was more involved in the day-to-day type operations of a medium-sized firm than I was, at a bigger firm. But no, I enjoyed working there. And then 6 or 7 years in, that firm changed dramatically. The firm, I call it imploded, but the reality is it's just a group of reconstituted, exactly. And they wanted to get rid of practice areas. I had an opportunity to stay, but there were 5 or 6 of us at Kluger that thought that Akerman would be better for our practice because it would provide a bigger platform. We could bring in corporate work. We could bring in intellectual property work. We could bring in land use and zoning. I mean, at a place like Akerman, there's a lot of different practice groups in there with all different types of expertise. Yeah. Plus, when I moved back, it had become a national firm with a New York office and a DC office and a Chicago office, things of that nature. So it gave me an opportunity to chase work outside of the state of Florida.
Okay, fine. So you convinced us about bankruptcy. Now we're all joining Akerman. Let's go. Are you taking resumes today?
Well, there's pros and cons.
I just wanted to touch on one thing because you're really good at this, and you talked about book of business and business generation, which is super important. You talked about that, but you're really, really good at it, and you've done a really good job of it. So what advice would you give to a younger lawyer that is looking to do that, to build their book, to build those relationships?
I would say make as many friends as you can, and use every outing that you can as an opportunity to meet people and tell them what you do, and establish, relationships and develop not just relationships, but friendships with people. I think that's important. The people that refer me work, are people that like me and who I speak with on a regular basis.
What are you talking about? We refer your work.
You've referred me a lot of work. You absolutely have referred me a lot of work. But that's because we have a relationship that we've built upon for 20 plus years. I remember, I've told you this before, though I don't think you remember, going to a concert with Jeff right when I moved down here in like 2004.
Been to a lot of shows. What show? The
Yeah, with your buddy Johnny
Kane.
Johnny Kane.
Shout out to Johnny Kane.
Johnny Kane reference on our podcast. Is that the first one? Is that the first one?
Probably, yeah.
The first one, yeah.
I had just moved down here, but we had some common friends.
That's funny, yeah.
So relationship goes really far, obviously, but you also have to be good at what you do, right? Because that relationship's only going to go so far.
Yes.
And
listen, you got to try 100%.
You have to be good at what you do, but that's not enough, right? You got to be likable too.
You got to be likable,
but there's a lot of people that are good at what.
I flip that. You got to be likable, but you got to be good at what you do.
Yeah, exactly. Yeah.
Because the likable will get you the first referral, but if you're not good at what you do, it may not get you the second or the third.
Yeah.
Right?
And there's different ways to be a lawyer and, make money. You see this in a bigger firm, and you guys may even see it, in your shop, which is there are guys that are great lawyers, much better than me, but they have zero interest in business development, business generation, which I think obviously is the cornerstone of what we do, but they don't have an interest in that.
Right.
Then you have other guys that are better at the relationship side of practicing law, which is developing referral networks, developing clients, but you need people to work on things. And I think you can make a good living being a great lawyer at a place where they need a great lawyer. You can make a good living as a guy who just brings in business, but isn't necessarily the best lawyer, doesn't want to, write 50-page briefs anymore and sit for 4 or 5 days of depositions. But it's the guys that can do both.
Right.
Yeah.
Which in my mind are really what I would call the superstars.
But I think
that are out there.
Some of that is identifying, for each attorney, what is their highest and best use. Because you're right. There are a lot of people who can do both, but still shouldn't do both because one thing is more unique or, it's in that particular firm. One skill set is, more desirable or more important to the firm or whatever it is. So.
Yeah, and it's interesting you say that because I have an old fraternity brother who was in the business of, he was like a rainmaker coach. And I was a 6th or 7th year lawyer and he heard about me going to court. He's like, Marks, the best use of your time is not going to court. The best use of your time is shaking hands, meeting people, and trying to bring in. You're better at that than you are going to court. So you should focus on that more. Yeah. By the way, he didn't know anything about my
great advice. No, but great advice.
Seen you in court, obviously, because you're
in court. But he thought, based upon personality, so it was better for me to sit at my desk and be on the phone or be going to meetings. Than it was to go into a courtroom for 3 hours.
Although back in the day when we were fully in person, I loved going to court because I could do both. That was one of the places where I could do both. I could, do the good legal work and also be pressing flesh and impressing people. Here's an opportunity to do a good job in front of your peers who are potential referral sources. I was like,
by the way, I agree with that 100% because it does remind me I'll call it
back in the days,
where I did when I was at the smaller firm and I was doing more consumer related work. We had a lot of smaller Chapter 7s and Chapter 13s. And when the courts would conduct hearings, they would have 15, 16 to 20 hearings at a time, all set for 1:30.
Yeah.
And you'd have a packed courtroom of lawyers waiting to go in for their 5 minutes of time that they were going to have. But you saw all of your buddies and all of your friends. And it was a great way to, shake hands, say hi and ask about the family. And I do miss that side of the practice of law because I really don't see that anymore. I don't go to court as much as I used to. When I do go to court, I would say probably 90% of it is Zoom related. So you see video of people, but you're not there. And you also have a better, you also got to know the judges better.
The times they are.
I was waiting for that. It's not the end of the world. The end of the world.
Not
as we know it.
Has changed dramatically.
Yeah, technology and
now to talk to Brett Marks, we had to bring him in for a podcast.
I know, live. We got him in live.
Trying to have lunch with the guy. We just had to say, fine, come for the podcast. And he only said yes because he didn't know really what it was about. So
I know.
You came here out of curiosity.
Now he's rethinking.
I was thinking to myself yesterday or the day before, how do I prep for this thing?
How do I get out of this?
Just
really what
you
he
be
was
you.
thinking of.
That's all. That's it.
And so far, you've done a great job.
Yeah. Thanks for coming
keep up
in,
the
Brett.
Good work, Brett.
We need to land this plane.
I've enjoyed this. If you enjoyed this as much as I did, I'd be really surprised if you're really telling the truth because I loved it. But if you enjoyed it, please leave us a review, share the show, follow us, subscribe, and we'll see you next time.
Thanks, Brett. Thanks, Nelson.
Thank you very much.
Thank you.
Thank you, Jay.
Thank you, Brett.
For more information on this show and other resources, visit fastamron.com and connect with us on LinkedIn, Facebook, and Instagram @fastamron.